Okay, so welcome everyone. Thanks for joining us today. Um, this is the FN Cares Spring Panel Discussion, First Nations and Class Actions, Reconciliation or Wreckonciliation, WRECK. My name is Melissa Britton and I'm your host for the webinar. We have today with us Dr. Cindy Blackstock from the Caring Society and Andrew Eckart, the staff lawyer from the Class Action Clinic at the University of Windsor. I'm honored to work as the research associate for FN Cares, which stands for the First Nations Children's Action Research and Education Service. FN Cares is a partnership between the First Nations Child and Family Caring Society and the Faculty of Education at the University of Alberta. We work really closely with the Caring Society towards ending structural inequities for First Nations children and supporting culturally based equity. To this end, we dedicate ourselves to learning and educating about a whole range of topics relating to our overriding goals. And this year we've discovered the need to learn about class action lawsuits and how they're being used by First Nations in attempts to seek justice. I'm a settler, scholar, and filmmaker, and I'm situated in Treaty 6 territory in Edmonton, Alberta, Amiskwichi, Waskiakan, Beaver Hills House. I just wanted to take a moment to acknowledge that Treaty 6, which includes territories across what we now know as Alberta and Saskatchewan, was signed in 1876 by representatives of the Crown and leaders of 50 nations, including Cree, Saulteaux, Nakota, and Dene peoples. The government's written documents contain information the First Nations had not agreed to orally. In particular, the First Nations agreed they would retain their inherent rights to the land, along with receiving access to reserve lands for the band, agricultural supplies, schooling for their children, medicines, food rations, and annuities promised by the government. But as far as the Crown was concerned, by signing Treaty 6, First Nations were, quote, ceding, releasing, surrendering, and yielding up to the government of the Dominion of Canada for Her Majesty the Queen and her successors forever, all their rights, titles, and privileges whatsoever to the lands, end quote, that made up their traditional territories. So you can see this is an early example of Canada's use of its own laws to mislead and control First Nations. And later we know came the Indian Act imposed on First Nations and many other restrictions and legal documents restricting and dispossessing peoples from their land. Since the numbered treaties were signed, many First Nations have persistently and creatively used the same laws of Canada to challenge the government's attempts to override their inherent rights to their lands, resources, cultures, and languages, and to ensure their rights are upheld and to struggle for justice. Our talk today will explore some of the implications of class action lawsuits, along with giving some of the basics. This is a fairly new legal tool, as I understand it, as the earliest class action legislation in Canada was only adopted in 1996, I believe. But many First Nations class action lawsuits are popping up today, and it's showing us that it's becoming an important legal tool, and therefore an important topic for us to explore. So just before I introduce Andrew, our first speaker, I just want to let you know, and you probably saw this already when you signed on, that this will be video recorded, but you will not be on video. Your videos are disabled. And so with the audio, you'll have a chance to interact with the speakers during our Q&A session. So what we're going to do is we're going to have Andrew, Cindy's going to start. Sorry, yeah, I forgot the order there. Cindy's going to begin and open up for us, talking about her experience a little bit and a lot of the questions that she has. Then Andrew's going to give us some background on class actions, and then we're going to drill him with questions and hopefully he'll be able to answer us. So Cindy and I first will raise some questions that we have, and then later on, in about 50 minutes or so, we're going to open up for Q&A, and you'll be able to enter your questions in the chat. So in the chat box. So please, anytime during the presentation, enter your questions in the chat box, and I'll be keeping track of them. And Um, that's okay. That's it for housekeeping. If you have any questions, put them in the chat box. I'd like to now introduce our first speaker, Dr. Cindy Blackstock, who is a member of the Gitxsan First Nation. Cindy is honored to serve as the Executive Director of the First Nations Child and Family Caring Society of Canada. She's also a professor at McGill University School of Social Work, and she has over 30 years of experience working in child welfare and Indigenous children's rights. Cindy has published on topics relating to reconciliation, Indigenous theory, First Nations child welfare, and human rights. In the fall of 2022, Dr. Blackstock received the Social Sciences and Humanities Research Council of Canada's Gold Medal, which is the funding agency's highest honor. The gold medal is awarded to academics in the social sciences and humanities whose research has significantly advanced understanding of their field and whose leadership, education, originality of thought have inspired both students and colleagues alike. And I would say have inspired most Canadians at this point. As many of you will already know, Cindy was also honored to work with First Nations colleagues on a successful human rights challenge to Canada's inequitable provision of child and family services and failure to implement Jordan's principle. This hard-fought litigation has resulted in hundreds of thousands of services being provided to First Nations children, youth, and families. Cindy is frequently seen in the company of the Caring Society's Wreckonciliation Ambassador, Spirit Bearer, and they engage children in meaningful actions to implement the TRC calls to action. So without further ado, I bring you Cindy Blackstock.
Thank you, Melissa, and I'm really honored to be here today. I'm joining you from unceded and unsurrendered Algonquin territory here in Ottawa. And I am just so grateful that Andrew's found time in his schedule to answer these questions, because as you heard from Melissa, you heard no expertise in class actions on my resume. I have a Master of Law degree, but I had heard the phrase, like many of you, and in our own family and community had survivors from residential schools applying for the settlement. And that was really the first big settlement I'd ever heard of, is in a class action fora. More recently, we have kind of had that exchange with the class action lawyers on the First Nations Child and Family Service and Jordan's Principle matters, where the Canadian Human Rights Tribunal had already awarded these victims $40,000. And when I became engaged with that, I had a lot of questions about class actions. It was one of those familiar words that I had heard. I kind of knew it was around, but I didn't know exactly what these things were. What rights do victims have that are defined within that class? Or if you're something called a representative plaintiff, what rights do you have even then? How are conflicts of interest all resolved in these class actions? And what are reasonable expectations you can have out of this legal proceeding? Every legal proceeding has its pluses and its limitations. And I was really curious to kind of hear about what actually on the ground these types of class actions can achieve. Because in our experience, what we found is that people who have been harmed in some way want mostly two things. They want the kind of compensation for the damages that were done to them, but perhaps even more important to many people is to make sure it doesn't happen to others. And I'm not too sure if class actions do both of those equally well, but we're going to find out from Andrew. I should just say at the beginning, we're not going to be talking about specific class actions in this, including the recent class action on child and family services and Jordan's Principle, which the agreement in principle was signed by, or pardon me, the Chiefs and Assembly affirmed a revised final settlement agreement last week. That's still going through legal proceedings. We may invite Andrew back to have a more detailed conversation about that one. But this is really about the whole plethora of class actions that seem to be popping out on all kinds of issues, from water to policing to child welfare. They're everywhere now. And I think it's really important that all of us as First Nations folks who are working and allies understand more about what these things are. So I don't want to take up much more time. I just want to say that I am joining you as an eager learner. I've got a lot of questions for Andrew. But at first, he's going to provide us with a bit of an introduction about what class actions are. And then I've got a whole list of questions, and I'm sure you do too. Again, we'll be dealing with general questions, not particular questions about persons' eligibility on one or more of the classes in today's seminar. So thank you very much, Melissa. I'll turn it back to you.
Andrew, thank you so much for joining us. Andrew joined the class action clinic at the University of Windsor as the staff lawyer shortly after the clinic opened in 2020. Andrew was first introduced to class action work as an articling student, clerking at the Superior Court of Justice in Toronto, where he assisted judges on many class action matters, including multi-year common issues trial. Following that, he worked in private practice as a plaintiff's side lawyer in class action lawsuits. In addition to his experience in class actions, Andrew has acted for clients in personal injury matters, employment disputes, as a commercial litigator, and as a Harvard-trained mediator. As the clinic staff lawyer, Andrew supervises and mentors student caseworkers, and represents clients through claims processes at settlement approval hearings, and providing important nonpartisan independent legal advice. How common is that? As the clinic staff lawyer, he also presented public interest legal arguments to the Ontario Court of Appeal in a case involving opt-out rights. Andrew sits on the Ontario Bar Association's class action bench bar liaison committee, and he's also a proud father and partner and Bernedoodle daddy. And he enjoys walking his St. Bernedoodle Esther in the parks, urban environments, and trails of Southern Ontario, especially with her new haircut. That was my addition.
Yes. Well, thank you, Melissa, for that wonderful introduction, and also for Cindy for inviting me here today to speak with everyone about class actions and the proliferation of them, especially with respect to First Nations people. So I'm going to share my screen. I have a little bit of a presentation set up, and we'll go through that, and then we'll have a Q&A with Cindy, and then open it up for everyone. So let me just make sure this is working. Can everyone see my screen, Melissa? Can you give a thumbs up or something?
I can see it, yeah.
Perfect. Okay, great. Well, again, good morning if you're on the West Coast. Good afternoon if you're where I am, which is in the city of Hamilton, just outside of Toronto and here in Ontario. It's situated on the traditional territories of the Erie Neutral, Huron-Wendat, Haudenosaunee, and Mississaugas. It's covered by the Dish with One Spoon Wampum Belt Covenant between the Haudenosaunee and Anishinaabeg nations to share and care for the resources around the Great Lakes. Today, the city is home to many Indigenous people from across Turtle Island, and we recognize, and I specifically recognize, that I have to do more to learn about the rich history of this land so that I can better understand my role as a resident, neighbor, partner, and caretaker. Stand in solidarity with murdered and missing Indigenous women, girl, transgender, and two-spirited people. I'm a first-generation settler in Canada, and I'm pleased to be here to share my experiences with you. So we'll talk today a little bit about class actions, but before we do, I'll just give you an overview of some of the topics that I'll be covering today in this presentation, and then we'll get into more specifics in our Q&A. I want to tell you a little bit about what the clinic does. It's a very unique program that we have at the University of Windsor. Then I'm just going to get into some basics about class actions, what they are, how are they different from the usual type of class or individual litigation. Do they go to trial? What happens when they do? How do they settle? Who is in control of how a class action proceeds? What are your rights as a representative plaintiff or as a class member? You may have heard the term opting out, so I'll clarify what that means a little bit. And then we'll talk a little bit about the settlement process in class actions, which is, I think, generally speaking, where most people have questions for the clinic, what the particulars of the settlement are, how they can participate, what rights class members have there. So let's get started. The clinic we launched in 2019. I've been the staff lawyer basically since the launch. I helped Professor Jasminka Kalajic, who's a professor at the University of Windsor Faculty of Law, start the clinic, and then we launched in 2019. Since then, we're proud to have helped many class members recover their share of settlement proceeds in various class actions. Recently, we crossed the $1 million threshold, which is a bit of a feather in our cap. We recently intervened in a case involving opt-out rights at the Court of Appeal. So we do some public interest litigation where it's appropriate to do so. We have represented objectors in proposed settlements, and I'll get into what that process is like as part of the presentation. And we've spoken with hundreds of Canadians all across the country who have individual inquiries about the status of class actions, and provided them with some information on those ongoing pieces of litigation, providing summary advice on opt-out rights, and so on. We are very proud of the work we do. We are unique in that there is no clinic like us out there. We received funding initially from the Law Foundation of Ontario, but recently obtained a contribution from a class action that settled, which has now provided us some financial sustainability going forward. All of that means that we provide our services free of charge to our clients. There's no financial eligibility requirements. Really, the only requirement is that you are a class member or a potential class member in a class action and have a class action related inquiry. I supervise a team right now of 4 law students that will be beginning May 1st for the summer, and throughout the semesters, fall and winter semesters at the University of Windsor's Faculty of Law, supervise a team of 4 students who do the work for credit. So we also provide an experiential learning opportunity for students as they're getting ready for their careers in law. So let's start with, what is a class action? Well, class action is what we call a representative action. It's a unique kind of lawsuit where one or more people sue the same defendants on behalf of a group of people who have the same legal problem. So that's where the word class comes up. That is the group of people who the action is intended to cover. The person who is named on the start of the lawsuit as the plaintiff is being proposed as a representative plaintiff. And we'll get into more specifics about the role of a representative plaintiff, but it is important to note at the offset that their job is to be a representative of the class and the legal issue that is the nexus of the lawsuit. A class action can only be called a class action once it has been certified, which is the first real procedural step in a proposed class action, which requires a legal test to be met and a court to consider whether or not procedurally this case is appropriate to move forward as a class action. As Melissa referred to early in her introduction of class actions, perhaps it was Cindy, I can't recall, these are relatively recent. This is a relatively recent process in Canada. The class action legislation in Ontario, where I am, was brought into force in 1992, and since then we've really seen a growth of these in Canada. they're older class actions, I think going back to the 70s out of Quebec, and there's some recognition under common law, but the real legislation that enables these and makes them more accessible for lawyers and the courts to deal with largely brought in the 1990s. The point of a class action, the reason these were brought in was to achieve three main goals. One is to improve access to justice, to allow people who have minor claims and who would otherwise face huge obstacles in terms of costs to access the courts to resolve these kind of claims, band together so that the economies of scale make it easier for somebody to actually get the justice that they deserve through that process. It was also the second goal to consider is the goal to incentivize defendants to modify behavior. We call this behavior modification. So whereas a defendant might think, well, wait a minute, if we just do these minor harms, that's really only allows somebody to claim $50, a minor price fixing matter or something like that. We'll never get sued because the costs are too expensive. So we'll continue with this bad behavior because there's no incentive for us to not do it. Class actions were seen as a tool to be able to modify that and to say, no, you're not going to get away with it this time. We have now this tool in our backpack. And finally, the third goal is to preserve judicial economy so that if there are thousands of people with the same kind of claim, you're not occupying thousands of courtrooms, the resources of 1,000 judges to deal with what is at the end of the day the same issue. It can all be streamlined into one process. Just as an example, in terms of what we mean by a class member or a class, a statement of claim will issue that says, John Doe is the representative of the people in a like situation. And I think it's always helpful to think of some examples. So I pulled up a few class actions that provided relatively simple definitions. There's a case involving Indian hospitals that is making its way through the courts right now. And the basic class there is defined as all persons who were admitted to an Indian hospital during a specific period of time. The 60 scoop class action likewise has a definition of everyone who's registered under the Indian Act and Inuit, as well as people eligible to be registered as Indians under the Indian Act, and were removed from their home between January 1st, 1951 and December 31st, 1991. So that's another example. So a very objective facts that allow you to self-identify whether or not you are in a class or not. Federal Indian Day Schools, a person who attended an Indian Day School. And if you go to the Federal Indian Day School class action website, you can see there's a whole list of schools that they have identified. So if you attended those schools, you're considered a class member, and that this action, and all of these have been certified, will cover your legal interests, and you will be bound by it unless you choose not to participate in it, which we'll get into in terms of the opting out process. So what makes a class action different from an individual suing to get justice? Well, it's because as a class member, you're going to have a limited personal relationship with your lawyer. If you're bringing an individual action, you are concerned about your own rights, your own interests, and you're going to work very closely with your lawyer so that they understand those interests and how your goals can be best achieved through whatever piece of litigation you're going through. In a class action, the lawyer has a duty to the class and the class members, but it is one as a whole. So it is not specific to the individual. The lawyer has to be very careful to ensure that they are preserving the interests of all class members, that there's no conflict between them, and specifically with the representative plaintiff. And that's the individual who is named on the lawsuit as the representative for all class members. So there's a limited personal relationship there. Class members don't have, because of that lack of a personal relationship with their lawyers, they don't instruct counsel. They don't provide instructions to say, we think we should settle this case. We don't think we should settle this case. We should go to trial. Those instructions come from that representative plaintiff named on the lawsuit. And that plaintiff, that individual representative plaintiff, has specific duties as well to instruct counsel and to ensure that there's no conflict between them and the class. Now, if a case does proceed to a trial in a class action, the issues that generally are dealt with are not particular to all the class members. Well, they're not particular to each individual class member. They are questions that are common to all or subcategories of class members. And that's what we call a common issues trial. That is, those questions are identified at the certification motion, which, recall, is the time that the judge says, yes, this is an appropriate case to proceed as a class action. So it's a list of 10, 12 questions, maybe less, that generally focus on questions of liability of the defendant. Did the defendant owe a duty of care to the class? Did they breach it? And as a result, are they liable for whatever damages come out of that? So if a matter does go through to common issues trial, there are often individual issues still remaining that need to be resolved. In an individual action, all of those questions would be dealt with at once in a trial, generally speaking. Finally, there is the court supervision. Because of the lack of autonomy that class members have in directing litigation, giving instructions to counsel about settlement and their participation, the court acts as a bit of a gatekeeper and supervises to ensure that if there is a settlement that occurs, that it is fair, reasonable, and in the best interests of the class as a whole. So there is that oversight in an individual case. Individual plaintiff, individual defendants can settle on whatever terms they'd like. The exception being if there's maybe an incapable person, there may require some court supervision. So minors typically require, even in an individual action, that a court approve a settlement. So that's court supervision is really important in class actions and is very much a feature of it that is not necessarily there in an individual action. Finally, and one of the things that make class actions really, what makes them successful now is, like I mentioned before, the costs. It might not make sense to bring a small claim forward. Individual lawsuits must be funded by the plaintiff, whether it's on an hourly basis to the lawyers or on a contingency fee basis, so that small claims might not make any economic sense to bring individually. But class actions, if you spread those small costs amongst a large group of people, become economically viable for class action lawyers. So one of the questions that Cindy and Melissa sent me in getting ready was, do all class actions go to trial, and what happens if they do? Most class actions don't go to trial. All class actions go to a certification hearing. Many don't survive the certification hearing. That is to say that while there might be a legitimate claim there, the court says this is not viable to proceed as a class action because the issues aren't common amongst the whole group. There are too many individual issues that make the class action too bulky, too onerous, and it just is not going to work well for anybody. So they dismiss, a case can be dismissed or not certified at the certification action motion. But then after that, if they do survive that certification motion, which is always the goal by the plaintiff lawyers when they start these things, then they often proceed to settlement or a dismissal of the case once there's a determination that, you know, maybe this is not viable now that we have more information through discovery processes that typically really happen after certification. That case then goes to the common issues trial if there is no settlement. And we'll talk about settlement details a little bit later. And those questions then that have to be resolved at the common issues trial, as I mentioned, concentrate and focus on questions of liability. So I pulled up a couple examples on this slide. For example, in the First Nations youth and the Jordan's Principle class action, one of the questions is, did the Crown's conduct infringe the equality right of the plaintiffs and class members under Section 15(1) of the Canadian Charter of Rights and Freedoms? So that would be the focus of the trial. That's one of many questions, but that would be a focus of the trial. Did, based on the facts of this circumstance that's common to everybody, did the Crown, Canada in this case, infringe on those Section 15 charter rights of equality? Likewise, the First Nations drinking water class action asks the question, from November 20th, 1995 to the present, did Canada owe a duty or an obligation to class members to take reasonable measures to provide them with or ensure they were provided with or refrain from barring adequate access to water that is safe for human use? So again, witnesses, documents, experts will testify whether or not there was that duty in law for the government to provide safe drinking water on reserve. So that is, those are some examples of questions that would be the focus of a common issues trial. And again, those are questions that are identified in the certification process as common to the class. So what happens after a common issues trial? Well, this is where I think it's pretty interesting in my view, but that's where there's an opportunity for the courts and the parties to develop procedures for the resolution of those individual issues. So a common issues trial, that this is sort of assuming that the answers are affirmative or helpful to the class members and the representative plaintiffs. Of course, if the court says, no, there's no liability, then that's that. The case is dismissed. But if there is some liability there, then it will be up to the parties and the courts to develop some type of process or procedure by which people can bring forward their own individual claims, knowing that liability has been established. So yes, the Canada or the defendant did harm. The question is now, how do you quantify that harm? And that changes for everybody. The legislation typically stipulates that the process should be designed in a manner that is the least expensive and most expeditious, consistent with justice to class members and the parties, keeping in mind this access to justice, judicial economy goal of all class action legislation. So generally, the process for making individual claims is there's some back and forth in terms of agreement, but there doesn't have to be agreement At the end of the day, the court can order whatever process they see meets those requirements under the legislation. And a good example of that is the federal solitary confinement class actions that have, I think the claims processes have just wrapped up on those. But there was a lot of back and forth between the parties, and eventually Justice Perel and his counterpart in Quebec approved a process, what they call an individual claims protocol, to determine how people can make their own claims. Well, what happens if they don't go to trial? Well, either they're dismissed because of some legal arguments, a motion for summary judgment, perhaps by the defendant, or there's a settlement. Now, both of these, as I mentioned earlier, are subject to court supervision. The court is the only one that can decide that this settlement is applicable, and it needs to make an order saying that the settlement is approved. Likewise, if there's a dismissal order, the court needs to make that, or a discontinuance in a typical individual piece of litigation. I don't need the court's permission to discontinue a claim, but in the class action process, you do, because the court has that gatekeeping supervisory function to ensure that those class members who might not even know about this class action have their rights protected. So they will be very careful about any ultimate result of a class action, whether it's settlement, common issues, determination, dismissal, or a discontinuance of a class action. So who controls how this all proceeds? Well, it is sometimes said that class actions are referred to as plaintiffless litigation, that they are lawyer-driven. I don't think that's completely true, though I can see why that comment is made. Lawyers do are in the driver's seat, but they do, and they have an obligation to take their instructions from the representative plaintiff, who they must keep informed and provide their opinions to, so that they can get instructions from that to take the next steps in the litigation. So the representative plaintiff, again, that's the person who's saying, I'm representing all these people in whatever defined class is, has to advise and instruct their lawyers, who are known as class counsel once case is certified. They need to fairly and adequately represent the interests of the class. So they can't put themselves above the class. They have to still understand that they are a representative of this group of people. So they need to understand, they need to fairly and adequately represent all of those individuals. So they have to understand what's going on with the lawsuit, understand the theories behind the case. They don't have to be, they don't have to go to law school for it, but they need to be properly informed by their counsel to make those important decisions that will need to be made. And it's very important that they don't have a conflict of interest with other class members. So because that can make things very difficult, as you can imagine, and there are several rules for lawyers to be cognizant of conflicts of interest. And if that should arise in a class action, if there's a conflict between one group of class members and another, it's very important that that gets dealt with in terms of directions from the court. Or if the representative plaintiff is not representative of the group, sometimes they can be replaced. What's interesting is that the representative plaintiff, I think, has a lot more control over the action than what we might imagine. They are the client that has the one-on-one relationship with class counsel, and they can actually choose who they want to be their lawyer. Now it would be, it's difficult to say what kind of case this would be, but if there is a breakdown in the relationship between a representative plaintiff and a lawyer, it's the representative plaintiff who can say, you know, I've hired a new law firm and I want them to run this instead of who I've had before as my lawyer, because it's my litigation. Now, terms of a retainer might have some things that you need to be very careful of as a representative plaintiff, but ultimately it is that individual's decisions that will control how the class action proceeds. At the certification motion, they file an affidavit in support of certification, explaining why they're an appropriate person to represent the class, and explaining that there's no conflict of interest, that they've been fully instructed by counsel and understand their responsibilities. In a settlement approval, likewise, they file an affidavit saying why they support this settlement, providing some history of their claims and why they believe that the settlement is fair and reasonable. While those decisions are important and those instructions, you know, would keep the ball rolling, again, class counsel is going to be very involved in ensuring that the representative plaintiff has all the information to get those instructions from. But there's still the court that is going to supervise all of those major steps: certification, settlement, class counsel fees must also be approved by the court, discontinuance or dismissal of the action, and then something we'll get into, which is notice. The court must approve notices of major steps in a case, like if a case is certified, if there is a settlement. What about class members? What rights do we have? Because we are all class members one way or another. I think we've all bought bread from a grocery store or purchased some small piece of computer equipment that is part of a price fixing class action. There are so many of these out there that it's hard to avoid being a class member. So you should know about at least 3 broad rights that class members have. One is notice. You have the right to know about what is happening in the class action. When a case is certified, there's generally a court-approved notice that goes out, and how it goes out depends on the case, the nature of the class, who they are, where they are. If they're all in one building, because it all has to deal with one building, then it's easy to mail out to everybody. But if they're spread across the country, which a lot of the First Nations class actions are, it's really important to get notice out there into various communities, no matter how remote, through whether it's print, audio, internet media, or flying out there and ensuring people understand what's happening with the case. Knowing about that this is a case that's been certified, whether there's a settlement or judgment. And those are the 2 major ones, because on both of certification or settlement, that means a class member has a choice to make. And that choice at certification is opting out. So that's the second right that class members have. It's very important for personal autonomy that class members know that they can choose not to participate in a class action once it's been certified. But to do that, they must provide their written, generally instructions or written confirmation that they do not want to participate in the class action to either class counsel or some administrator. Because if you don't, then you are considered in. And there's a deadline by which that needs to happen. Some deadlines are longer than others. Generally, it's about 6 months, could be a year, could be a little shorter, could be a little longer, depending, again, on the makeup of that class. So very case-by-case investigation and determination. If a class member decides to opt out of a class action, that means that they can start their own case. They're not going to be bound by whatever happens in the class action. They can commence their own individual litigation. An interesting example of that, it's for lawyers anyway. There's a case in Saskatchewan dealing with the Humboldt Broncos tragic bus accident that happened a few years ago. While some of the families started their own individual litigation, there was also a class action at play. And there were a couple decisions, and ultimately the Court of Appeal said that just because there's a class action doesn't mean that these individual class actions don't get to also proceed through the courts. Sometimes a court will say, we are giving priority to the class action. The individual actions are stayed, meaning we're not going to proceed with those until there's been some resolution in the class action. So important, if you are considering an individual case, to pay attention to those certification and opt-out deadlines so that you can properly opt out of the class action. And if you are doing an individual lawsuit, you're probably already in touch with a lawyer who should make that known to class counsel sooner rather than later, even perhaps before certification. And then again, hand in hand with notices is the notice of settlement. Not just that a class action has been settled, but that that class action has been settled, but there is a settlement that is being proposed to the court for consideration, because a settlement can't go into effect until a court says this is fair, reasonable, and in the best interests of the class. If class members don't think it is, or they don't have all the information, they should, and I encourage them to speak to class counsel, raise their concerns, or get their own lawyer who may object to the class action object to the settlement, excuse me, if that's appropriate to do so. So that's where the clinic has represented clients on occasion to raise our objections to terms of a settlement that we didn't think were fair, reasonable, or in the best interests of the class. And so you have, once you receive your notice of a proposed settlement, then an opportunity to object to it. I'll just get into a little bit more detail about approval of the settlement and how to object. So you'll get the notice, as I mentioned, of a proposed settlement. It generally will spell out who are class members, some of the details of the class action or the settlement, what it covers, and also explain some of the fees that class counsel may be seeking as well. And it should explain to you, if you wish to object to the class or to the settlement, that there's a manner by which to do so, a deadline, and a place where you would send your objection. And then if it's just in writing, or that complaint or objection will be put into affidavit materials that will be before the court for consideration at the settlement approval hearing. But there's also an opportunity, generally speaking, for class members to speak and raise their objection in person or via Zoom to the judge who has that difficult decision to make. Again, ultimately, the court must decide whether a settlement is fair, reasonable, and in the best interest of the class as a whole. Doesn't have to be perfect. Settlements are a compromise, generally speaking. So there are things that the court will consider, such as what's the risk of continuing on with litigation and not settling? What is, what's the likelihood of recovery? Maybe a defendant might be on the verge of insolvency. So this is really the best outcome, even though you have a very good case. All these factors play into whether a court is going to decide whether the settlement is fair or reasonable. A court can't change the settlement. They can only either approve it or deny it. Now, that's not to say that judges haven't said, if it weren't just for this one clause or this one thing, I would completely agree that this is a fair and reasonable settlement. Come back to me if you can resolve that one issue. And that's happened on occasion. Or the parties in the room might say, yep, we've got our instructions. We agree to get rid of that small clause, what it is. But a judge can't, on these kind of motions, substitute their own settlement, because a settlement is by its nature a negotiated agreement between parties. So it needs to be agreed to in order for it to be a settlement. Again, representative plaintiffs will instruct their lawyers on the reasonableness of the settlement once they've gotten their legal opinion from their lawyers to approve it or not. And we should also note, part of settlement approval hearings is fee approval. And in most class actions, counsel's fee is a contingency fee arrangement, meaning that it will be a percentage of the net recovery or the gross recovery that the parties have agreed to. So it can range from 10 to 30%. A $30 million settlement may have a $10 million fee that the lawyers are seeking to also have approved. And the settlement hearing is an appropriate time for class members to also raise concerns about fee requests. That is the nutshell of class actions that I ran through a little longer maybe than we had anticipated. So I apologize for that, but there is a lot of material to get through. I hope that was helpful for you, Cindy, Melissa, and everyone in attendance today.
Yes, thank you. Thank you so much, Andrew. That was really helpful. I think it probably raises even more questions. I don't know if you agree, Cindy, but I wanted to give you the chance to start and follow up with Andrew if you have any questions after that.
Yeah, Andrew, I'm thinking of myself as you're talking as maybe a person who's experienced some kind of serious harm, as in many of the First Nations class actions was the case. So, for example, a residential school, being placed in residential school, or in the 60s scoop, being removed from your family, or even this contemporary one, or being denied water. And I'm walking into a lawyer's office and I want to be compensated for my harm, but more importantly, I want it to stop. And when I'm in there with the lawyer, do they have a legal obligation to tell me about all the different remedies I have available versus steering me towards a class action, which would get them more legal fees? For example, through the Canadian Human Rights Tribunal process or other types of legal remedies that might be available. And then to provide me information about maybe it is better that I go on my own. If I have had such a serious harm, maybe it's better I go on my own versus being a part of a class action. So how does that all work out?
Yeah, that's a great question. So a lawyer's duty is to their client foremost. So if that is the concern of a client, I think it's prudent for a lawyer to communicate that a class action may be an option, but then to talk about what are the pluses and minuses of going that route, and to consider whether that is the avenue for systemic change, that if that's your priority, or if you're an individual who is just concerned about your individual harm, it is so much worse than, while you can recognize that there are many other groups of people that also were harmed by this, but maybe not as much as you, then it might make more sense to go individually because it's a stronger case for yourself. So the lawyer's duty, though, is to the client. So, I mean, if you're in a class action law firm's office, I think you're already there because you're contemplating this. And that's typically, where you're going to have those kind of discussions. It's a very highly specialized area of law that there's a very small bar. There's a very small amount of lawyers that specialize in it. So if you're there in one of those firms, you're probably there because you have a reason to be. But it's a great question that all people who are, potential representative plaintiffs have a discussion about with their lawyers.
Yeah, because I think for many of us, we're so, like class action, it just seems to be the remedy that people go to before, versus having that opportunity to see the wide array of things. And one of the questions I have for you is with regard to this kind of prevention on the respondent end. So I get that the class action's intent is to kind of hold that entity or that individual, the wrongdoer, responsible by paying these sums. But what kind of success have you seen in class actions and actually fixing systemic problems? Are they that successful at doing that?
Yeah, that's a great question. I think they are. I think they do really have a great potential to do that. I'm thinking about Indian residential schools. If it weren't for the class action, I'm not so sure that we would have the National Center for Truth and Reconciliation, the Truth and Reconciliation report authored by Murray Sinclair. Those were the product of a settlement agreement that happened in that context of the class action. Likewise with the apology from Parliament on Indian residential schools. So I think those changed Canadian society in a way that we hadn't had a reckoning before. I can't say it's all because of a class action, but I certainly think it was a very powerful tool that enabled representative plaintiffs who were sophisticated, who were able to properly instruct counsel and work with counsel to come up with a process. And what do we really want? Yes, of course, we want to be, remunerated for the harms we've suffered, but we also want this never to happen again, and to reflect upon what has happened and ensure that, as a culture, as a society, we are aware of these things. So what can we do in that respect? And if you have a willing party, a defendant that's looking to not just pay off the money and have it done with, but actually engage in a process of reconciliation or behavior modification, then you do have a real opportunity to use this as a tool to guide those settlement negotiations and come up with novel ideas that might actually reach to that systemic change.
Would they have the ability to do what the Canadian Human Rights Tribunal did in terms of forcing Canada to implement Jordan's principle, to pay prevention monies to stop that kind of thing? Do they have that reach, or is it kind of confined to apologies, setting up commissions and that kind of thing?
Well, a settlement, I think you have a lot of room to do almost whatever you'd like, as long as it's within the context. If you have a broad enough claim that you've filed, you can capture all kinds of things in it. But I think, that the CHRT made its decision, but likewise, a court could do that as well. Or the parties can just agree, right? Like nothing's stopping parties from agreeing to whatever they want, as long, again, as it's fair, reasonable, best interest of the class in the context of the class action.
And you talked a lot about the courts, and I've had my own experiences in front of various courts. This area of law is very complex. How much training do they get on class actions, and how much training do they get on the experiences of First Nations, Métis, and Inuit peoples, who are more often than not the subjects of systemic discrimination, and often are the groups that are covered by these class actions?
That's a great question. And as a former clerk, I have a little bit of insight. Judges do go attend conferences, and judges are often especially in class actions, specialized in that area. Now, that's not to say that there's a judge that's never done class actions before who might just be starting on their class action rotation and learning about it, but they're only going to do that if they have a real interest in it and are willing to learn. So there'll be some training through the National Judicial Institute, as well as, they communicate with their colleagues on those kind of issues as well. But there are several judges in Canada, in the various provincial courts and the superior courts, as well as the federal court, who almost only do class actions. So they really develop an expertise in that area. In terms of training for judges on First Nations issues, I can't speak to that, but I do believe that there are some calls for action in the Truth and Reconciliation report for that specifically. I mean, there are for lawyers, for law students, so I it must be for judges as well. When they do have these issues, I've heard from some who have spoken who they want it. They want to understand that, because they have to understand that context in order to rule fairly on some of these issues, get a little bit more of an understanding of the history of especially treaty disputes and so on. So there is continuing education for the judiciary there in that both those respects.
Okay, so that's good news. Let's shift for a minute if I'm a subject of one of these. And in fact, it may be that it's a First Nations one, but it might be a non-Indigenous class action. For example, the convoy one here in Ottawa, we might be eligible as a caring society because our business was affected during that time. So you could be kind of coming off that way. If we've seen in First Nations class actions, I'll speak honestly as an individual, some of the lawyers in previous class actions, they've been brought in front of law societies, et cetera, for their terrible behavior, particularly in the IRS settlement. Mm-hmm. So how do we safeguard against, I appreciate it's a minority of the group, but they're out there, these folks who are kind of in it for the money more, and maybe are not acting in the best interest of the class and more often the best interest of themselves. So what remedies, if I'm a member of the class action and I see some of this stuff happening, then maybe I'm a community member and I see bad behavior, what kind of recourse do I have?
Yeah, that's a good question. It's the IRS example. I mean, what some of those lawyers were doing was not in accordance with any rules. So it's almost to say it doesn't matter what rules are out there. There could be people that are in breach of them, and they're supposed to be stopped from doing it, but they certainly aren't. There has been in more recent times. I'm thinking of the Federal Indian Day Schools class action. I'm thinking of 60 Scoop class action. There's been a recent trend to actually have class counsel provide legal support for claimants. So when a lot of the class actions I was doing as a plaintiff side lawyer, once we settled and we had a settlement claims process out there, we almost said, okay, we're done with that. We're gonna supervise. We're gonna make sure that money gets paid out to people, but we're not assisting people make claims. In Indian Day Schools and 60 Scoop, class counsel was actually required to provide those services, assist people make their claims in those class actions. And in Federal Indian Day Schools, actually, you needed, if you weren't class counsel, if you weren't from Gowlings, you would need permission to be able to assist folks. And so the settlement agreements sometimes stipulate that there's only a certain amount of fees that you can take, up to a certain percentage of recovery for each individual claimant. I think that's the case in the solitary confinement class actions. That while you can enter into a contingency fee agreement, that is, the lawyer will take a percentage fee it can only be up to a certain percentage. It can't be the full 30% that may be allowed, or 35% that may be allowed under the Solicitors Act. So there are some tools available, but again, what I think is really an important aspect of class actions is that creativity to allow an opportunity in the settlement and claims process design to come up with some solutions that can assist folks, and think about it. And I always encourage people, think about it from an access to justice perspective. Think about that claimant. What are the possible scenarios that pop up in this situation? Unscrupulous lawyers, difficulty understanding notice or the process, type of evidence that needs to be filed. How can we make this easier for folks? How can we make sure that they have an easy line in to actually get that money that we fought so hard to, get that entitlement to?
That's right. They've already been harmed. You don't want the process to harm them more.
That's right.
If anyone has questions on these different things, they can get a hold of your clinic, which is so fabulous, right? Like that's the one thing that I just think is such a great resource. And a couple more questions, and then I see Melissa has some popping up in the chat. One of them is specifically about children. We in this class action that was approved by Chiefs and Assembly last week, that involves tens of thousands of children who are still children. We've seen around the globe class actions filed against the Catholic Church for children who are still children. So where is the status of the law in terms of protecting particularly children who are members of a class action?
Yeah, so I guess it's class action specifically, there are no rules for that, but we do have a lot of protections in the law for infant settlements or children, how they are represented in courts. You don't have to wait until you're 18 to bring a lawsuit, but what you do need to do is have a legal guardian. That could be a parent, grandparent, sibling, or it could be a family services agency who can actually act as a litigation guardian, or somebody who is assisting this person throughout the process, and who has this fiduciary relationship with that child, and can ensure the forms are filled out and filed appropriately. Otherwise, the protection is to wait until you're 18, until you're a legal adult, to bring your claim, because the limitations period does not necessarily start for a child until they turn that age of majority. So there's that protection as well. But it's a tricky one. I had a note, let me just cover, because that was a question I was prepared for. So yeah, so you'll have your guardians. Sometimes there's, and this is not necessarily child specific, but dependent adults who have mental capacity issues may be involved with the Office of the Public Guardian and Trustee. And I was just reading yesterday about, there was a few class actions that settled in Ontario involving institutions, schools for people with such conditions, who then had to file claims, and the Office of the Public Guardian and Trustee was the one who was ultimately responsible for doing that for those individuals. And it's really, really important for class counsel, if they know that their makeup of their class is a particular subset of the population that needs extra assistance, that they think about a claims process that accommodates that, but also that the people involved, like the Office of the Public Guardian Trustee, have everything that they need in order to make that smooth for them. I think I read in a report that they wrote for the Law Commission's report, a study into class actions in Ontario, that they had something like 346 individuals that they had to file claims for very quickly in a 5-month period, with complicated harms that occurred. So really important, again, to have that claims process designed in a way that's accessible and that those issues are thought about. The other one is records. There's always there's an opportunity to also think about access to those records that usually might require a court order, but a class action judge in approving a settlement might be able to actually say, okay, well, I'm also on consent agreeing to enable this type of process so that whatever ministry has those records isn't saying, you need to file your FOI request and then get approval from the court under the Youth Criminal Justice Act, processes that could be also expensive. So important to keep all of those things in mind. But I think the fundamental issue is, who is your audience? Who are the class members? And what difficulties, what barriers are there for them to access justice?
Right. Not only receiving the compensation, but after. That's what First Nations Youth and Care have talked to us is, what happens the day after the check is already deposited in the bank? Who's going to be there to kind of support me? And I think that's one of the things class actions can do, is build in some of those supports too, which is so important. So Melissa, I know that you have some fabulous questions in the chat. I'm going to turn it over to you.
Oh, thanks, Cindy. And thank you too for that great discussion, that back and forth. Some of these questions may already been answered and maybe are a little more specific. Anna Laura Pachulo has asked, how long generally is the class action process? It seems that the harm at the center of a class action can be identified as trauma. Do you find, well, not a lot of cases, I would imagine. Do you find that the length of the process or anything else having to do with the process can be re-traumatizing?
Yeah, absolutely. And, we deal with a lot of clients. I'm thinking of federal Indian day schools where the claim form, if you're making a higher level claim, you need to disclose the harm that's happened to you. So while some of that trauma is, the re-traumatization has been we've tried to minimize that through the claims design by not exposing people to cross-examinations, which can be really devastating. There still is that fundamental discussion that needs to take place. So all of our students at the clinic are trained in, we run trauma-informed lawyering training right off the start. I just think it's good for all lawyers to have in place, no matter who their audience is, but specifically because we have a lot of clients that come from traumatic experiences that we need to talk about. So there is that. And in terms of, and this also ties into how long of a claims process, like how long does a class action take? Well, class action could take a decade. What was the Gottfriedson case just settled? That's the banned reparations case. I think it was filed in 2010 or 11, just was settled in February. So that's over a decade. But I think what's really important once it has been settled is that you have lots of time for people to file their claims, because day one, while they might want to get in there and file their claim right away, they might not have had enough time with somebody to properly process their entire experience, in which case they may be shortchanged if they settle, or if they just file a checked box type of claim that says, yes, I've suffered harm, but I'm not going to go into it. So working with professionals, working with elders, working with there's so many different organizations that are doing such great work in terms of providing support for people to be a little bit more comfortable with their trauma and to be able to communicate their experiences a little bit easier. And then getting involved with maybe a lawyer who can put it into that framework of, okay, we need to, establish, particular kinds of harm, that it's permanent, long-term, and so on. So it's a great question. And again, going to claims design needs to be thought of. And I have to say, in the last, almost every settlement now that deals with institutional institutional abuse generally has a term or part of the preamble saying we're designing a process that's trying to minimize re-traumatization. Now, as much as you say that, the proof is in the pudding, and we need to be cognizant of that. But I think parties, like, that is their desire. That's what they want, because they know it's fair and is needed.
Thank you. And Laura Beaudry also, I think that might address her question about, is it possible to have no limitation period to apply for monies? And she just talks about the limitation periods are too short. So you're talking about the settlement design that would be negotiated within the class action as something that needs to consider all those things.
Yeah, so it's a good point. The limitations question is an interesting one. So in the last decade or so, most provinces have gotten rid of limitations periods for any sexual assaults, so that they've completely gotten rid of the time limit. But if you're now dealing with a class action where part of the harm is sexual abuse or sexual assault, you're imposing a limitation period on class members, because they now have, there's always a filing deadline. They're never going to agree to a term where there's no deadline in the future. If somebody needs to file a claim because, we've set it aside X amount of dollars for these claims, and, it's time limited in terms of applications. So it's a really interesting thought process. One of the suggestions I've seen is, well, if you are going to put if you are going to have sexual assault as subject matter of your class action, perhaps instead of making it an opt-out process, make it an opt-in process. So somebody says, well, I want to participate in this class action, so I'm consenting to now being bound by whatever claims deadline is out there. Because the opt-out process means that people need to make a specific choice to remove themselves from the class action. And now we're saying, well, now you're, and if they don't do that because they don't know about it, then they're bound, and they're bound by the settlement, they're bound by the limitation of the claims period, and so on. So maybe making it opt-in for sexual assault subject matter is a reasonable type of process that folks should consider.
Right, and people are also asked to opt out before they know what even the results are going to be or the settlement's going to be.
That's an excellent point. Yeah, we have a lot of settlements that occur years after certification, and certification is the time when you need to make an opt-out election. But there's a lot of class actions also that happen that get certified at the same time as settlement. So that's, and in those cases, that's, I think the best scenario for class members, because they'll have information about, okay, do I want to be included in this? This is what the settlement is that's out there. If I don't think that settlement's fair to me, I can say right now, today, don't even put me in this process. I'm not participating. I'll take my, I'll go get my own independent legal advice, perhaps start my own individual action instead.
Yeah, that's so interesting. I just noticed too, when Cindy shared the link for the compensation and reform of First Nations Child and Family Services in Jordan's Principle, which I'm just going to post right here to everyone in the meeting. They have an opt-out of the class action extended until August 23rd, 2023. So you can already read the decision and then opt out. But like you say, people have to know that they're even included in class before they can opt out.
Yeah.
And then who knows, I don't know yet how long people will be able to make those claims. I know in some cases, I think it's one of the First Nations class actions that are going on right now. the settlement period has been extended. So that happens sometimes too, I understand. But
Yeah.
like, it all means nothing to somebody if they're not informed. So how do people get informed? Like, if they know nothing about this, is it in newspapers? Is it in, like, how do people get informed?
Yeah, it's a great question, and it's it used to be newspapers almost, that was the only way you'd ever learn about a class action. But there's been a little bit more research into how to reach targeted audiences. Obviously, the internet has a lot to do with that. So you see more Google advertisements, Facebook advertisements, social media, just ads saying, does this describe you? If so, you should know that, there's a claims process or there's some certification going on. But I think it's really, really important for courts to take a very close look at that notice. How effective is it really? I think we easily fall into traps as plaintiffs counsel or class counsel to say, well, this is how we usually do things. This is our, notice program. It's worked once before, so we'll just do it again in this other case. But I think it's really, really important to take that step and say, okay, who are we talking about? Let's put some effort in. Do we need to hire a marketing professional or whoever it is that can really tell us who our audience is, where they're located, and how do we reach them? And I think that when you're talking about First Nations that are spread all over the country, farthest northern communities that may not have broadband internet access, you need to specifically think about how they get their news. And if it means doing it, I think, it's important for people to just go to those communities, have information sessions, let people know what's going on, because without notice, what good is it all at the end of the day? Yeah. Because the courts are pretty strict about saying, look, I've approved the notice program. It's gone out according to my order. If you don't know, I'm sorry about that. You've had your opportunity and now it's done. So unless there's a really good excuse about why you didn't opt out when you had to, or you didn't make your claim when you had to, you're probably not going to get that second kick at the can.
That's great. Yeah, for sure. Andrew, thank you. You've been on the spot for quite a while now, a good hour. And I just want to give Cindy a last chance to have a few words or ask a very last question. We have 3 minutes left. Oh, you're muted.
Thank you. So, Andrew, thank you so much. I joined Melissa and thank you. This is a lot to absorb about these class actions. And in addition to your clinic, is there any kind of national list of these? And is there, like, I'm a frequent airline passenger. There's a Bill of Rights for passengers. There's a Bill of Rights if you're getting insurance from an insurance company. Is there any kind of national kind of legal standard that really enshrines those rights and makes it as easy for me to be able to access as a possible class member to understand what my rights and responsibilities are in these things?
Oh, that's such a good idea. Maybe we need to be that place. Our website does have a lot of information, and I encourage everybody here, reach out if you have, especially if you are a class member, you have specific questions about your own particular circumstances. I welcome you to please come contact the clinic and meet with me and the students, and we can discuss your own situation. We have some information on our website. We're about to relaunch, so have a little bit more information out there. There's a couple registries. Quebec has really done a really good job of having a registry in there with their courts about all their ongoing class actions. And that's on the Quebec's court website. There is also the Canadian Bar Association has a national registry of ongoing class actions. That's not as comprehensive really as it should be. counsel are supposed to voluntarily submit their cases there, but don't always do so. We're developing, part of our new website is to develop an area of settlements. So we want to make sure that we have current ongoing claims process information available. Class counsel have their own websites generally now for all class actions, so you can follow those. If you know you are a part of a class action, I encourage you to find that website, register. There's typically a register button, because then you'll get generally the notices that go out by email about any developments in the case, and they'll have some information for you. So yeah, there isn't a comprehensive place, one-stop shop, but let's see if we can at least fix that a little bit at the clinic with our new website, and I'm hoping some of that information that people are looking for will be able to be there.
That'd be terrific. And I know for many First Nations, like only 35% of them have broadband. So when I see people just relying on electronic notices or things like this, you know, it's really an access to justice issue, and it gets in the way of people finding out when they can have they're part of a class action, when they can opt out, when do they have to get their claim in before that claims period expires, all kinds of challenges. You have been so helpful, Andrew. I have got a whole bookload of notes myself about things I learned, and I know just enough that we have to invite you back, because I'm sure that as we're kind of learning more, we will have more specific questions for you as well about how we follow these class actions through. Melissa, thank you so much for all of your excellent work. And I'll turn it back to you for a final word.
Okay, thank you. Thanks, Cindy, so much for joining us. And thank you, Andrew, for joining us. What a great opportunity. And I'm sure Cindy and I will have we'll invite you again. And
thank you both for organizing this event. It's always my pleasure to spread the word about what we're doing at the clinic. And again, if anyone has questions, just please feel free to approach us. We're easily accessible online. If you have broadband, I guess you do if you're here. And just send me a note or give us a call, and be happy to hear from you.